Good morning, everybody, and welcome to Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you, everybody, for being here. Good morning to you, or good afternoon, or good evening, wherever you are from in this entire world watching today. Happy Memorial Day. Thank you for joining us on a holiday weekend, and especially on a day that we're remembering those lost in service to this country. So thank you for being here. Happy Memorial Day. Hello to everybody in the chat. I can already see Shy Gal and Afton and Rainy Day and Hannah UK and Hazel. A lot of familiar names, a lot of new names. Hello, Jen. Happy Sunday Fun Day, everybody. For those of you who are new, welcome. This is Sunday Fun Day from Courtroom Confidential. My name is Joshua Ritter. I am a former prosecutor with the LA District Attorney's Office. I was there for 10 years or so, and then I left and went into private practice as a criminal defense attorney. I've been doing that for nearly as long. This is Courtroom Confidential, where our goal, our mission, our desire is to be as objective as possible and present to you both sides of the courtroom, and we hope that we do that. This is Sunday Fun Day, you lucky folks, where we answer as many questions as we possibly can that you have left us in voice messages throughout the week. I also want to say hello to our Facebook people out there who are watching this live streamed on Facebook, and to everybody who's watching it on replay. Maybe you were not able to join us live, but we appreciate you, and we always read your comments. And I have made it my goal for as long as I possibly can on this channel to respond to every comment that you guys leave. If you take the time to leave a comment, I'm going to take the time to say thank you for it. So before we get started, please like this video. Please subscribe to this channel if you haven't already. We're trying our best to do our best for you, and the best way we can do that is through your support. So thank you for that. We have a lot of messages that were left. We tried our darndest to get to all of them, and we're not going to be able to do it. There are some that we have missed. Do not despair. We're going to get to as many of you people who have called, especially people who it's your first time calling in. I appreciate that. And we'll make it up to you if we missed you. We'll make sure to get you the next time around. And we also wanted you to be able to get out of here and not have a 4-hour-long stream and go on to the rest of your holiday weekend and barbecue and play in the pool. I set up the kiddie pool outside for the little ones, and they were splashing around all day long yesterday, and I'm probably going to have to do that again today. The pool is not that big, and every trip to Target means that we get more floaties to put inside of it. So pretty soon it's going to be 90% floaty, 10% water, but they're having a good time, and I hope you guys are as well. All right, let's go ahead and jump right into these calls and get us going on these things. Who's going to kick us off? Oh.
Hi, Josh. This is CB Kansas calling from Kansas City, Missouri. My question is kind of a challenge to you, actually. I would like to know if you can put your prosecutor hat on and make an argument for why a trial, any trial that you want, either one that's going on now or one that's going on in the future, why a trial shouldn't be televised. I know you used to be a prosecutor and you're a defense attorney now, but I'm curious to know how you would make an argument for a trial not to be televised or to not allow cameras in the trial. Thanks. Bye.
Thank you, CB Kansas. Going on the map. First one on the map today, Kansas City, Missouri, representing Kansas City, Missouri. Thank you so much. Great question. Interesting thing about this. Her question is, what, as a prosecutor, I guess, especially from that perspective, when would there ever be a situation where we would not want cameras in the courtroom? It was interesting. During my time at the DA's office here in Los Angeles, our official position was we had no position. And I think that's the way that a lot of prosecutors' offices handle it, because we don't want to ever appear as though we're trying to hide something. So you would have problems, I imagine, if the prosecutor was saying we don't want cameras in courtroom. Not a good look. So the official position from the DA's office here in LA, and I think it still is they have no position. If there's a media request, we have no objection. If the defense objects to it, we take no position on that. But I think your question is more about when would I personally ever object to cameras in the courtroom. I am a firm believer, even if I wasn't fully enmeshed in this world of watching trials and talking about them, I am a firm believer that the more cameras we have in courtroom, the better. I think it is, you know, what do they say? The best, I'm going to screw this up. The best disinfectant is sunshine. The best way to make sure that everyone feels confident as much as they can in the system is to shine a light on the actual work being done. I fully believe in that. And I think a lot of these cases have public interest and public intrigue, and we should know about what's going on and how they're actually happening. And when we don't have cameras, it leads to a lot of issues and problems. So that's my official position. But is there ever a situation where I can understand them not having cameras? And I think there are. And I think that's when it's dealing with really sensitive subject matter. If you're talking about sexual assault type cases, and you're going to have many victims come up and go through horrible things that they've experienced, things involving children, talking about subject matter like that, abuse, and you've got kids who are going to testify. And usually courts, I think across the board, will not have the cameras on when those folks are testifying. But sometimes they even defer to not having the cameras at all in those types of cases because, you know, last thing we want to do is have public interest further discouraging people from coming forward. So I think that all efforts are made, especially in those incredibly sensitive cases, to make that person feel comfortable in testifying. They're already going to be in a public courtroom. By the way, when there's no cameras, you can still go into the courtroom. So it's still a quote unquote public courtroom. But we're just not going to broadcast that to the world. And I think the other situation might be when there's other types of security issues. When you're talking about undercover operations, and maybe you don't want these officers testifying being identified for some real, you know, really in-depth undercover work that they have done that might put themselves or their loved ones at risk. Thank you so much, Rowena Rains, for your kind words. Mafia cases, military secrets type cases. You could understand where a little more discretion and secrecy might be appreciated in cases like that. But I think, again, vast majority of cases should be televised. And I think we need to change the federal system here in the US, and those cases should be televised as well. It's long overdue. There's no reason for not having transparency in federal cases. I mean, this Diddy case is of incredible public intrigue, and that's not televised. Kind of nonsense to me in this day and age. Great question, CB Kansas, calling from Kansas City, Missouri. Thank you so much for kicking us off this morning. Let's keep it rolling.
Hi, Joshua. Joe Schmo here, originally from Lafayette, Indiana, and for the past few weeks, months, residing in Mesa, Arizona. So you can put the pin where you decide to put the pin, but I do have a couple of questions about state filings, state motions, and the LoriVallow Daybell case. They filed back on April 11th, so during the first trial. But regarding the new trial, a notice of intent to use the defendant's other acts to establish conspiracy, premeditation, and or motive pursuant to Rule 404B. So they filed a 404B motion, notice of intent to use that, but then we found out this week that they withdrew that. So I'm kind of curious why they would file it and then withdraw it. But we also kind of have a similar motion in the state's amended request for Rule 609 hearing, which they filed on April 27th. So Rule 609 is to determine if the court or if the state can impeach the defendant with her prior convictions. So we know she now has a new prior conviction that wasn't included with her 609 hearing for the first trial. So I'm just kind of curious your thoughts.
Thank you so much, Joe Schmo. You asked us to pick where we're going to put your pin, where we're going to put it in Lafayette, Indiana, because that's where you say you hail from originally. Good to hear from you, my friend. We appreciate the work that you're doing, especially on the LoriVallow case. And it's just good to hear from you, as always. Interesting question. So Joe points out that there were a couple of motions filed in the new case. LoriVallow, as you know, is on trial again. I feel like we're going to get deja vu for the amount of times we hear that statement being made, but she's on trial again. This will now be her third trial. This is for the attempted murder of Brandon Boudreaux. It's again taking place in Arizona. She's again going to represent herself. And I found out that I was wrong. It is going to be streamed, but on a delay. So we will follow that case. But Joe asked the question that it looks like a motion of a notice of intent to use 404B evidence was filed and then withdrawn. Why was that done? And then what is the deal with this 609 motion being filed, and what does that mean for this new trial? So great questions. Let's unwind it a little bit so everybody can understand what we're talking about. A 404B motion is dealing with prior bad acts. We've talked about this a lot. This is where you're allowed to use character type evidence, but not for character, to prove something other than character. So they talked about they want to use it for perhaps motive or to show conspiracy. And they filed it, and then it looked like they withdrew it. So they do not intend to use those prior bad acts. And I think what's going on here, and obviously I'm just trying to read the tea leaves, but I think what's going on here is prior bad acts evidence. When you're able to show somebody doing something bad, committing some sort of crime, either charged or uncharged in the past, that can have both an incredibly powerful effect on the jury because it can demonstrate to the jury how this person has done something similar in the past and how they can use that in deciding whether or not they did the crime that they're charged with here. But it is probably the type of evidence most often misused by the jurors because we are splitting incredibly thin hairs with them when we ask them to do something like, listen, let's take LoriVallow as an example. Hey, ladies and gentlemen, she's on trial for attempting to murder her niece's ex-husband. By the way, she was just convicted of murdering her own husband. We don't want you to use that to say, hey, once a murderer, always a murderer. We want you to use that to show how she's got a similar motive in this case as she did in that case. Or we want you to show it that she had a similar common plan or scheme in the case where she was convicted and apply it to this case. Do you see how that becomes difficult? Do you see how we're really asking the jurors to take to do a tightrope walk there? And sometimes it can be misused. And so I think discretion on the part of the prosecution is always good because these are, by the way, one of the first places appellate courts look to in overturning cases. Harvey Weinstein is now on trial in New York because his original case was overturned because of a misuse of this type of evidence. Yes, Farm Girl, it's a slippery slope. So it can be incredibly powerful. When I was a prosecutor, I tried to use it at every opportunity I could because it is so powerful, but it can be misused. Turning now to the 609 evidence. So to answer your question, Joe, I think they just withdrew it because they thought to themselves, we don't need it. Let's not cause trouble. Now turning to the 609 evidence, impeachment with prior convictions. I think that is just making sure that they lay the groundwork in case she does decide to take the stand in this case. And they want to know exactly ahead of time, pre-litigated, what judge are you going to allow us to get into? In my view, when somebody takes the stand, they should be fair game for pretty much anything. So if she takes the stand, the fact that she was convicted for her husband's murder, I think is fair game. The fact that she was convicted for the murder of her children and her new husband's ex-wife, I think should all be fair game. Part of a juror's job is to assess the credibility of the witness. And if that witness happens to have a very colored, textured, interesting background, that's part of assessing them. But judges do try to weigh these issues, and they try to say, is it more probative than prejudicial that they learn about her prior conviction? In other words, what we don't want is a conviction in this case based almost entirely on the fact that they know about her convictions in other cases. So, great question, Joe. I think they're just laying the groundwork in case she decides to go ahead and testify this time around. I was shocked she didn't testify at the first trial. Maybe she'll go ahead and take that opportunity this time around. Great question, Joe. Appreciate you. Lafayette, Indiana. Let's keep it moving along here.
Hi, Josh. This is JC Broadway from Salt Lake City, Utah. I'm on the map. It's a rainy morning here, and I thought it'd be a perfect time for a quiz. I did try to come up with a trivia question for Joy W. from Canada on proffers or something from your homework material you gave us last Sunday on hung juries, but I'll have to flesh those out another time. All right, here's the question. Notebooks ready. You are a criminal defense lawyer named Joshua Ritter, ESQ, representing a client who has been charged with fentanyl possession. The police found the fentanyl in the guest bedroom of the client's uncle's house when responding to a noise complaint at the house. Before entering the house, the officers knocked on the door. When the uncle answered the door, the officers asked if they could look inside the house, and the uncle agreed. The client did not live in the house and was not there at the time of the search. The client had stayed in the guest bedroom of the house 2 nights prior to the search. The uncle told the officers that the client was the last person to have slept in that room. You are considering filing a motion to suppress the fentanyl under the Fourth Amendment. Which of the following legal topics are the most important for you to research to determine the likelihood of success on a motion to suppress? Select 2. A, consent search. B, exigent circumstances. C, hot pursuit. D, probable cause. E, reasonable suspicion. And F, standing. I'll leave the answers in another message.
Great question. I love this. This stuff gets me juiced. I love these types of questions, and it's a really good one. I'm going to play you guys the answer, and I hope you believe me in this. I did guess ahead of time, JC Broadway, and I did get it right, which made me take a breath of relief, because I thought, if I don't know this by now, I've got problems.
And the answers are A, consent search, and F, standing. I did not get the standing part right. Anyway, hope y'all had fun again. I'll talk to you later. Call me back. Bye.
All right. Did you guys get it? Consent search and standing. Thank you so much, JC Broadway from Salt Lake City, Utah. First of all, let's put you on the map, and thank you so much for contributing to the conversation this morning. Let's break it down. So these are, first of all, consent search, I think, does stand out as being a likely answer to this. We're talking about, and really what we're talking about, and I think what I would focus in on if I were the defense attorney in this case, is what's called the reasonable officer standard. In other words, would a reasonable officer, under the circumstances, realize that they had received consent to make the search? And that's really what the judge will focus on as well. Yes, consent was given, right? Somebody said, sure, go ahead and take a look. So if that's where our inquiry stops, that's not much of a discussion. But then the discussion becomes, does that person have the ability, the capacity to give consent? And is the officer acting in a reasonable manner by believing that person had the capacity to give consent? So that's the first question of, is officer knocks on the door. The part that I didn't hear in that question was person identifies themselves as living there. So that will be a question. Should the officer have known that person lived there or not? What other circumstantial evidence might the surrounding circumstances might allow the officer to believe that they did in fact live there? June, you were fantastic. Thank you so much for the gifting memberships. Appreciate you. So that would be the first kind of thing we would get into. You know, does the person come to the door dressed in their pajamas, looking like they live there? Did they say anything about that's my truck parked in the driveway? Anything like that that would lead the officers reasonably to believe that the person they're having the conversation with can actually give consent. In other words, if you knock on the door, or if you walk up to the door and the Amazon delivery guy is standing there and you say, can we search this house? Probably not a reasonable belief on the officer's part that that person has the ability to grant consent to search that home. So that's kind of the first question that you want to get into. The second question, though, why is standing important? Because it's not the person who gave the consent, who answered the door, that has a problem with this search. It's, in this scenario, my client who happened to have stayed the night 2 nights ago in a back room. They're the ones who are questioning the Fourth Amendment issues at play. They're the ones who have the argument to be made. Do they have standing to make those arguments? In other words, do they have a reasonable expectation of privacy in that bedroom? And that's an interesting question as well, because standing and consent can be given to the owner of the home. So in other words, somebody who owns the home but doesn't necessarily live there. To the people who live in the home, they can have standing to question that search, and to overnight guests. And that's the third one where it becomes interesting. Now, you might say, well, what if the owner, the person who answered the door, has a problem with that search? They're not the people versus, right? They're not on trial. Their problems with the search are not at play here and not a concern to the court. It's the problems, it's the questions of the defendant. The defendant's not the owner. The defendant didn't give the consent, and the defendant doesn't own the home or doesn't live in the home. The defendant was an overnight guest from 2 nights ago. And so really the question will become, does staying 1 night 2 nights ago give you standing to say, I didn't grant consent for this? To add one more wrinkle to this, if 2 people have equal ownership, equal right to use or occupy a home, you only need consent from one of them to search the entire home. So in other words, if husband has been arrested for possession of fentanyl and wife answers the door and says, sure, you can go ahead and search, that's good enough. And the fact that husband pounds his fists at trial and says, I never gave consent, is not a problem, because they got consent from somebody who could have given consent, and that's all they need. So I think in this case, JC Broadway, excellent question. I think it's a losing motion on the part of my client, unfortunately. And as we were talking about this, it made me think about Bryan Kohberger. This became an issue. You remember, not to get too much on a tangent here, but you remember Bryan Kohberger was, there was a lot of issue and a lot of question about whether or not the use of the IgG DNA inquiries, the fact that the FBI had gone into these databases where the people in the database had not given consent for their DNA to be used in this type of a capacity, whether or not that created any kind of issues. And the judge did a similar analysis here. First of all, Kohberger has no expectation of privacy in discarded items. So Kohberger, likely the person to have discarded that sheath. I know that some people are going to question that, but he doesn't have standing because he doesn't have an expectation of privacy in a discarded item at a crime scene, the knife sheath. But do the people who are in the database have standing to say we didn't want our DNA used in an analysis to lead to the investigation of this suspect. No, they don't, because it's not the people of the state of Idaho versus anyone in that database. They can rant and rave and bring a complaint against the FBI's office, but as far as for the judge in the Idaho case to be making his decisions on this, the only one before him is Bryan Kohberger, and Bryan Kohberger doesn't have an expectation of privacy that these people have, if that makes sense. I know I'm kind of going around in circles here, but that was the inquiry that the judge did. The people whose DNA was used, they're not on trial. Bryan Kohberger is, and Bryan Kohberger discarded an item. And the fact that the FBI used that in some sort of way that other people might have a problem with is not a problem for the judge in the Idaho case. So great question. Love the quizzes, JC Broadway. I guess I will continue to hang my diploma and take in new clients that I didn't fail to answer that question. All right, let's keep it moving. Wonderful questions, you guys.
I was wondering if you'd ever encountered a situation in your practice where a special prosecutor was appointed to investigate leaks in a trial, and what you think the likelihood is of them finding out who leaked the information to Dateline. Thank you so much. I love your show. Bye.
Thank you so much. Megan, loved hearing from you. Didn't hear your location. Next time, let us know. I appreciate you leaving a message and asking such an amazing question about, this is about the Dateline leak. This is a big, I've heard mixed responses on this. I've heard some people say it's not that big a deal. A lot of this stuff has been covered before. And I've heard others, myself included, saying it could be a big deal. The judge is treating it like a big deal. And the reason we know the judge is treating it like a big deal is that he said, I want an inquiry done. I want to know who leaked this. And I think you guys should get to the bottom of it. And he suggested to the prosecution that they assign a special prosecutor to investigate this. So why a special prosecutor? First question. Because the DA's office can't investigate themselves, is what he's saying. So you need to hire some sort of outside, independent, objective body to get to the bottom of this, who's not only going to investigate the defense, but also investigate you folks. I think that's a good move. I think that will make everybody feel like the job is being done correctly. I don't think this should be handed off simply to the prosecutor's office to investigate themselves. I think they should do their own investigation, but I think for everybody to feel like they've gotten to the bottom of this, I think a special prosecutor should be appointed. To your question though, Megan, have I ever dealt with that? No, never even heard of it. Never even heard of a situation where there was a leak of such magnitude in the middle or in the lead up to a trial that this kind of inquiry and investigation needed to be done. So it is a big deal. The judge is bothered by it. Both parties are bothered by it. And the question becomes, how bad could this get? Well, if you are a regular listener to Courtroom Confidential, I talked about this yesterday in our weekly roundup. It could get bad potentially. I don't, and I hope that it won't. I hope that if they are able to determine who did this, and your other question was, do I think they will? I think they will. I think that they will probably, I don't think it was such a wide open case that anybody could have gotten their hands on this information. I think that somehow they will find whoever did this. And then depending on who did it, will answer the question of how bad it could get. Here's two scenarios to consider. One, it was a low-level data entry clerk. And I am not disparaging data entry clerks, but I'm just saying somebody who was not directly involved in the investigation of this case, somebody who just handled, computers at the, let's say, the prosecutor's office or the defense. By the way, the defense, in my view, is under as much scrutiny as anybody. but somebody who is not an investigator involved directly in the gathering of evidence in this case, and somehow they got their hands on it and they said, hey, Dateline, I've got something interesting. Do you got a couple of bucks to throw my way, and I'll give you some interesting information? I will say that Dateline kept on referring to this person as someone close to the investigation that is a trusted source. So whatever that means. That's one scenario. If that is the first scenario, then probably not horrific. Probably people will lose their jobs, admonitions will be given, judge will still be upset, but we'll move on and we'll move towards trial. But imagine this nightmare scenario. Imagine that the person who leaked it was very involved in the investigation. And take it a step further to say, what if the person who leaked it was the officer that recovered the knife sheath? Now you've got the person who recovered the single most crucial piece of evidence in this case. Make no mistake, it rises or falls on that DNA. If that DNA gets kicked out, I don't even know if you have a case. You got a bunch of other circumstantial evidence, but to tie them all together in a neat bow, you need that DNA there. If that was the person, then you're talking about the bias of that investigator, I mean, we're not just saying things like, hey, I want to be able to cross-examine on this. We might be having discussions on whether or not that knife sheath comes in. Will it get that far? I don't think so. Is the person who recovered it the leaker? We have no idea. I hope not. I don't want to get everybody all worked up about something that's just in my imagination at this point. But if anybody's trying to tell you it's not a big deal, it hopefully is not, but it could potentially be a very big deal. But thank you, Megan, from the universe somewhere. Let us know where you're from if you're listening this morning, and we'll put you on the map. But thank you so much. Great question. All right, let's keep it moving.
Hi, Josh. This is Diane from Salt Lake City. My question is about a pro se litigant and questioning their victim. Is there a restriction on what the litigant is allowed to ask? And also, is the litigant allowed to approach the victim on the stand with evidence? Personally, if I was a victim, it's going to be extremely hard to allow them near me.
Hi, Diane from Salt Lake City, Utah. First of all, let's put you on the map. Interesting question. And I imagine you're asking this because of the LoriVallow case. I'm trying to think of another kind of high profile case that we've covered where the person was, the terms used are either pro se. Here in California, where I practice, we call them as pro per. Just people representing themselves. And what are the restrictions on what they are allowed to ask? First of all, the same restrictions that any attorney is allowed to ask. They have to follow the evidence code. They have to follow the rules of court and the evidence code. So there is not special restrictions put on them. But they have to follow the same rules as everybody else. And if that includes asking argumentative or badgering the witness, and that's what your concern is, they're going to get stopped cold. But other than that, if they follow the rules, they're allowed to do the same kind of robust cross-examination that anybody is allowed to do. The other question was, can they approach the witness as an attorney might to present documents or whatever else? There's no rules on that. It's up to the judge. But I will tell you, I've handled a few pro per cases and I've never seen it happen. For the most part, they stay exactly behind the table. And in fact, in most cases that I've had, they don't even approach the podium. And there's a very large deputy who's armed, standing very close by at all times. If somebody's pro per and in custody for a violent type crime, there's a lot of security concerns for them walking freely about the court. I'll tell you a story. I had a really, just so you know, the concerns going for the court and how we will still allow people to exercise their constitutional rights even under extraordinary circumstances. I had a pro per defendant when I was a prosecutor, and it was It was a very bad domestic violence case. It was kind of a sex worker pimp type situation, but she referred to him as her boyfriend, but he was being incredibly abusive to her and making her do awful things and had her living in a state of absolute fear and desperation for a very long time. And he was representing himself, and he had actually bailed out. So he was out. Well, as we're approaching trial, I can't find her. And finally, the detectives are able to track her down. And she says that since he's been out, he's actually made contact with her, assaulted her again, and threatened her life if she actually showed up to court. So now what do I do with this? I went to the judge and I asked to go ex parte, meaning I'm going to speak to you without the other side present. Judges will allow that. If there's, you have to explain it to the judge almost immediately why you're asking for it, because they're reluctant to do it. But the judge knew this was a case that probably required it, and the judge trusted me. So I go back there and I lay this all out. And I said, Your Honor, I'm bringing this up to you because I am not going to put this all on the record that we know this, that the victim has been brave enough to come forward and tell us about further attacks that she has suffered at the hands of the defendant if you're not going to lock him up. So I will put him out on the record, and I will put all of this out there if you can tell me that with this information, you will remand him and keep him in custody, because I'm not going to further threaten my victim. And she said, sounds good to me. So we brought him out. He showed up to court. He's a free guy, shows up, happy as can be. Good morning, Mr. Ritter. He was quite a character. Happiest guy in the world. Hello, Mr. Ritter. Good morning, Your Honor. I have something I would like to put on the record. And I just laid this dude out, and the sheriffs in court absolutely knew what was going down. And he was in handcuffs before the judge got her order out. And I remember him being brought back into custody. We had to set another court date. He's still representing himself. And the whole time he's looking over at me going, Mr. Ritter, Mr. Ritter. It was like he was offended at the lack of professionalism I had shown him. Anyhow, he represented himself at trial. He cross-examined my victim in that case. And it was brutal. It was uncomfortable. It was awful, but she was incredibly brave. And I was so proud of her because she looked him square in the eyes and said, you mean when you beat me? You mean when you did X, Y, and Z? And there was a lot of stuff I don't want to share here that she testified to. She had gone through hell with this guy, but she looked him square in the eye, told him exactly what he did, and he was convicted. So that's how things can get in court. Thank you so much, Diane from Salt Lake City, for asking the question. All right, let's keep it moving here.
Hi, Josh. It's Sue from New Zealand. I've got a question for you. I'm thinking about LoriVallow, and there's recently a doctor accused of killing his wife. I can't remember his name, and I just caught it really briefly. But I just wondered how difficult it would be to be in jail and having to prepare your defense, working maybe with your lawyer and preparing your defense. This doctor that I can't think of what his name is, but he has got to interview lawyers to find a lawyer. I don't know whether it's a stalling tactic with him because he's had quite a while to do it, my understanding is. But yeah, can you just talk through that process? Like, how hard is it to do that process, to LoriVallow, sending out subpoenas, she's got to talk to witnesses and things. How hard is it to prepare your defense if you're in jail or prison in America? Yeah, that's just my question for you. Thanks.
Thank you so much, Sue, calling from New Zealand. Let's put New Zealand on the map. There it is. Beautiful place I've never been to and I would love to go to, but I love that we have supporters and subscribers and listeners calling from there. So, Sue, you're asking about LoriVallow, but then you also mentioned, and I think the doctor you were looking for, whose name escaped you, is Ingolf Turk. This was a really fascinating case that happened not too long ago. He was accused of murdering his estranged wife. A bizarre story about how they had, were trying to patch things up, and then things took a turn, and he ended up strangling her and beating her and then weighing her down in a nearby pond. He was charged with first-degree murder, and I think he was actually convicted of manslaughter, which shocked a lot of people. But your question is more about defendants who are in custody, and how does that change things? How does that change the dynamic? I will say it is extremely difficult to represent somebody who is in custody. It is a game changer. It really is. And that is why bail motions are one of the most important parts of a case that oftentimes get overlooked. When Sean Diddy Combs was denied bail in his current case, his entire team lost their brains. They have asked for bail several times. They were willing to put up in property and cash, I think it was over $100 million. If you want to know how important it is for somebody to get out while their trial is pending, that's how important it is. People are willing to give up nearly their entire net worth at the chance of just being out while they fight a trial. Why is that? There are many reasons. First of all, you don't have the same kind of time concerns, right? You got a client who's in custody. They want things done. When you're saying to them, hey, I need a couple of weeks, a couple of months to do X, Y, and Z with an investigator, that's 2 weeks, 2 months that they're sitting in prison longer. They want this thing handled. They want to get to their trial. And as much as you try to tell them, I need the time to prepare, because this isn't just about you getting out or getting to trial. This is about you being a free person after trial. The last thing we want to do is rush to get you to trial because you're impatient and you're sitting around here. Then you get convicted and go to prison for the rest of your life. But those conversations begin to wear thin with people who are just sitting around, because you put it out for 2-3 weeks or a month, they're sitting in jail just thinking about what are you doing the whole time. So it makes that much more difficult. Then there's just the logistics of it. These jails are sometimes hours away. This isn't a matter of picking up the phone, doing a Zoom phone call, having the client stop by the office. Sometimes we're talking about your entire day is spent driving to a jail to meet for a few minutes with your client, to then drive back. Whole day wasted in the car just trying to give your client a little bit of attention. And then sometimes you show up and they're in lockdown. So you turn right back around and you don't get to speak to your client. The whole jail's in lockdown. You didn't know about it. Nobody informs you. Even when you get to meet with them, you've got no privacy. You're sitting there sometimes in a room with other people around, and you're trying to have these whispered conversations that sometimes can be, they are not monitored because you're the attorney, but you don't know who's listening. Not as far as like police illegally listening, but people walking by, what are they picking up? And then when you do meet with your client, they're exhausted because they have not slept well and they're not eating well. And these conversations, I can't tell you how many times I've had conversations with people who are in custody, and we spend most of the time just talking about how they're doing. I can't eat. I can't sleep. You got to get me out of here. This is miserable. What's going on outside? Where's my wife? Why won't she visit? All of this kind of stuff. And you're like, Joe, I've got 13 more minutes to talk to you here. We need to talk about your case a little bit. I will tell you, it is a game changer, and it's exhausting. And that's why, if at all costs, getting your client out just to prepare for trial could be a world of difference. Thank you so much for the question, Sue from New Zealand. Appreciate you. All right. Let's keep it moving here, guys.
Hello, Josh. I'm Carmina from Valencia in Spain. And I mentioned this case like 3 weeks ago when you were talking about another case of someone who had been wrongly convicted. And this is the most famous case in Spain ever. Like, it's really famous because it was absolutely insane. You know, imagine the media circus with Johnny Depp, but multiplied by 1,000. And yeah, I mean, it was. If you watch the documentary, I will mention later, you will understand it. But yeah, basically, it started because Rocío Hornos was killed when she was 19 years old in October of 1999. She was stabbed 8 times in the back, but they were looking, everybody in the village, in Mijas. It is in Malaga, in the south of Spain. So everybody was helping to find the body in the mountain and everywhere, but because she disappeared going to a fair at night, so they couldn't find her body. And when they found her body, so because they found her body a month later, it was too late to determine if she had been sexually assaulted or not. And this is important because 2 years later, in 2002, the police detained Dolores Vázquez with no real evidence against her. But she had been in a relationship with Rocío's mother, with Alicia. They had been a couple for many years, and they had been raising Alicia's kids from another relationship together. So when Rocío was killed, they had already broken up. They were not a couple, but Rocío's mother thought she could be the killer because she thought she was jealous of her relationship with Rocío and that she wanted to come back together with her, which Dolores denied, but the popular jury convicted her, and I think it was for 15 years, but she only spent 17 months in jail because in 2003, and in a village not too far from there, Sonia Caravantes disappeared, but this time they found her body much faster this time. So they were able to determine how she had been killed, and more importantly, they found DNA under her nails, and this DNA matched a cigarette found at the scene where Rocío's body had been left. So they realized that they had been killed by the same person. And this person was Tony Alexander King, a serial killer from the United Kingdom who had been in jail, was released, then committed more crimes, and then came to the south of Spain. Dolores Vázquez was released after 17 months. And you can see 2 documentaries about this if you are interested. There is one called Murder by the Coast on Netflix. In Spanish, it's called The Case Vallow Caravantes. And the other one should be on HBO Max, I guess, because they are who produced it. And it's called Dolores, The Truth About the Vallow Case. It is a mini-series with 6 episodes. And it's an interview. It's the first time that Dolores sat down in front of the camera to tell her story about her experience.
Thank you so much, Carmina, from Valencia, Spain. First of all, let's put you on the map. I think this is our first call from Spain, so that's exciting. So glad to hear from you. So glad that you're a listener of the show, and appreciate you contributing. And if you're listening right now, I say hello to you. Hola. Thank you for that message. That was the story. That was a great in-depth kind of telling of it. I don't want to retell it again, but I'll give you kind of the highlights. And I mainly liked hearing it from Carmina in her beautiful accent. and the way that she pronounces these names that I'm about to butcher for you. But yes, I had not heard of this story. And it is wild. I watched this documentary, Murder by the Coast. It is on Netflix. I did my homework. Thank you, Carmina. You asked me and I delivered. It's wild. It's well worth a watch. And it's probably something I would not have watched had you not brought it to my attention. But you could see if this case were here in the States, it would be something we would all be talking about all the time, because the twists and turns this thing took were incredible. But here's the highlights. Yes, this poor girl, Rocio Waninkoff, goes missing. Beautiful girl. Friends are waiting for her. She was supposed to show up to a fair, never makes it home. No idea where she is. The entire community in southern Spain there go looking for her. And there is a huge man search. She's found about 10 miles away. Her body has completely decomposed. It's mainly bones. They can't tell exactly what has taken place, but it looks like she's been stabbed several times. And there's an incredible amount of pressure put on investigators and the police to solve this murder. And this is the part where I couldn't quite understand it, but it sounds like it was like a cultural lost in translation thing as to what exactly went on. But the investigators zero in on this woman, Dolores Vasquez. So Rocio's mother, however the relationship ended with her father, she started to have this love affair with this woman, Dolores, and they had been together for a very long time, to the point that Dolores had taken part in kind of the raising of Rocio and her other children. And the investigators, and this is the part that I kept on trying to feel like, am I missing something here? I will tell you that the vast majority of this documentary is done in subtitles because everybody's speaking Spanish. So there's a lot of reading. You're going to have to read this documentary, but it's well worth it. But it was almost like they came up with this theory that Dolores must have been jealous. And Dolores sounds like she's got an interesting kind of personality. She might rub people the wrong way. And it was like, that was enough. Okay, you're kind of an unlikable person, and you probably maybe had a reason to not like Rocio because you wanted to stay with her mother, and that might have caused some conflict. So you're the one. No physical evidence, no eyewitnesses, nothing, just a hunch, just a motive. And they put this woman on trial. And again, I got to kind of educate myself on this, but it was like the judges are the jury. I'm not quite sure how it all works, so forgive me if I'm wrong. But they convict this woman and they give her 15 years. She's going to prison for this murder. No explanation as to why, the stabbing, the potential sexual assault, the transportation of the body, nothing, none of that. We just kind of didn't like, and the media gets everybody worked up about this, and everybody's convinced that she did it. And she's being, people are calling her a murderer in the streets every time she shows up to court. It's just an absolute mess. And she would have stayed in prison had it not been for another very unfortunate woman, young lady called Sonia Carabantes. She goes missing. And there's evidence that she was assaulted and kidnapped right outside of her home. There's her shoes are found there. There's some blood. There's a broken taillight. I don't mean to trigger everybody, but there's a broken taillight. Oh, Gisela. Hey, everybody. Good to see you. Hello. Happy Sunday. This is you should look into this one, Gisela. Crazy case. So police have a little bit more to work on. And what they find, to not prolong this story and ruin the documentary for you, still watch it because I'm probably not telling it properly. They find evidence that Sonia had fought back, and there was some genetic material, some DNA found, I think, in her fingerprints. That is a positive hit for a cigarette butt that was disposed near the scene where Rocio was abducted. Now they believe the same person who killed Rocio is the same person who killed Sonia. It's obviously not Dolores because she's been in jail, and they now believe it's male DNA. Long story short, this all leads them back to a person from England by the name of Tony Alexander King, who, by the way, had committed a bunch of sexual assaults in England and basically fled to Spain. And the English authorities let the Spanish authorities know that. And everybody was like, okay. Like, no, Interpol sent out this thing. Be on the lookout. This guy's bad news. Okay, whatever. A lot of really awful stuff. Anyways, Dolores ends up getting out and vindicated. Dolores is like, you people are, there she is. You people all can all, sit on a, you can all take a hike. I don't know what to say that's not X-rated. She's upset, right? Rightfully so. Never really gets a vindication, never really gets the media to say we screwed up, never really gets the prosecutors to say they screwed up. They end up convicting Tony Alexander. He goes away to prison for the rest of his life. It's just a dramatic case. But still, my biggest question, the thing that was most appalling and left me most bothered by all of this, was how did they possibly convict this woman? Like, what is going on that somebody like that can be? You want to talk about nightmare scenarios where innocent people can go to prison? I don't know what in the world they had on this woman other than a hunch. I mean, that's it. If hunch evidence is enough, I hope you step on a Lego. Yes, I hope you step on a Lego. Great one. It was appalling to me. Check it out. Murder by the Coast on Netflix. Carmina, thank you so much for sharing that story with us. I loved hearing it, and I always appreciate hearing about cases I'm not familiar with. And Martha Ivy, thank you so much for joining the crew. Appreciate you. All right, let's keep it moving here.
Hi, Josh. This is Pam calling from Michigan. Just wondering, as I'm listening to various podcasts on the Vallow Daybell, the Daybell, Bryan Kohberger, even Sean Combs, KarenRead, how do the court staff, the lawyers, even the judge, I suppose, deal with all the evidence, the graphic nature of the evidence, the photos, the information, everything? How do you guys deal with that? That can't be so easy. And I know that the judge in the Chad Daybell did offer the jurors a couple appointments for mental health counseling. I didn't know if that was offered for you as well, lawyers, everybody. I just feel like having to look at that and listen to it and know the details, even if some of it isn't disclosed during court, it's got to be so hard. So just kind of wondering how you guys handle all that. Anyway, great day. Happy fun day, Sunday fun day. Love your show. Talk to you soon. Bye.
Thank you so much, Pam from Waterford, Michigan. Let's put Waterford, Michigan on the map. Appreciate you calling in. I get this question every so often about how do you deal with the graphic nature of evidence and photos? And do we have any help for that? Well, the first answer is no, we don't have any help. Never once has it even been suggested if you need some mental health counseling as a prosecutor, we've got it for you. They provide those types of services for victims and everyone else, but it's just kind of seen as doing your job. And I think that's why you see a lot of especially law enforcement detectives getting burnt out, the alcohol abuse, everything else. It's a difficult thing to deal with day by day by day. We did an interview with Joseph Scott Morgan, who was a medical I'm not getting his title right, but he was like a forensic medical examiner for a very long time. And you should check that out. It's in our conversation playlist. Wonderful guy, but he talks about the burnout. He talks about just day after day, you can't seeing this stuff. It begins to wear on you. As a prosecutor, you're a little bit removed from it, you know, because you're not exactly getting called out to every scene and watching it in front of you. But sometimes you are, and it's difficult. And I think you compartmentalize and you put on your prosecutor hat, and you realize that you've got a job to do. And I've seen many, many, many graphic photos. I will say the stuff I struggle with is not the photos as much as the people testifying. I had to put a little girl on the stand, talk about witnessing her mother get murdered right in front of her and having the guy who shot her mom chase her down the street. It's difficult to hear that stuff. And it's hard to put somebody through that and knowing that you're putting them through that. And that really gets to me. The photos, not as much. I don't know if that makes me as sick in the head or what. Whenever somebody asks me this question, I always think about what I'll refer to as the head on the bed case that I dealt with. If you know, you know. I've talked about this before on the channel. I'll get into that again at another time, the details of it. But it was probably one of the most haunting photos I've ever seen of just a human head right in the middle of a cleanly made bed. But I think the case that bothered me the most as far as graphic photographs, I worked as a law clerk here in California. We had the 2005 Glendale train wreck. There's a photo of it. This was a really horrific case. A man by the name of Juan Manuel Alvarez, who was, I don't know if he was suicidal or if he was just a narcissist or whatever he was. He decides to park his car on the train tracks, and it ends up derailing one commuter train that then crashes into another commuter train going the opposite direction. So it derails and horrible collision to two commuter trains. 177 people are injured and 11 people are killed. It was horrific. The photographs from this case were some of the most disturbing things I've ever seen in my life, because we're not, it's one thing to see a person who suffered a gunshot wound, and it's another thing to see a person who's been stabbed and even a person who's been mutilated. But the carnage done to a human body when they are just basically twisted and ripped apart because of this huge collision. I don't want to get overly graphic, but I didn't know a human body could end up that way. I mean, we were looking at photographs of people, and it was hard to even determine where everything fit. I mean, they were just ripped apart. Really awful stuff. So that's the case that comes to my mind, and that was a difficult one, but we get through it. You just got to present the evidence and get the job done. That was an interesting case too, because the underlying crime that allowed us to seek the death penalty in that case was train wrecking. Train wrecking is still a crime eligible for the death penalty in California. You know when the last time somebody was on trial for train wrecking was before this case? I do. 1873. Because I had to do the research on the motions we wrote in this case, and we could not find another case since 1873 in California. Train wrecking still on the books. You commit a train wrecking in California, they're still going to go after you. But it was a fascinating case for a number of reasons, and actually the jury did not go for the death penalty. He got instead 11 consecutive life without parole sentences. So fascinating story. Thank you so much, Pam from Waterford, Michigan, for asking that question, and appreciate you being a part of the conversation. Let's keep it going.
Hi, Josh and everyone. This is Sneemak from Alexandria, Virginia. And as some people in the chat know, I'm a neuroscientist. I actually examine neuroscience and neurosurgical patents for the government. But I'm really fascinated by the intersection between neuroscience and true crime. And there's a case out of Massachusetts. It's the case of Jose Veguilla, Veguilla, who murdered his nursing home roommate named Robert Boucher, Boucher. Now, because Jose has very severe dementia, he's been deemed unfit to stand trial and sent to Bridgewater State Mental Institution. But he's been there since 2019. And due to the nature of Alzheimer's, he will never be restored to capacity to stand trial. So he's kind of in this limbo holding pattern. His family is very concerned about, reasonable detention and your right to a speedy trial, which seems to be not happening anytime soon. So my question for you is, where do you see this area of law going? And because it seems to be a very gray area, and it's only going to become an increasing issue with an aging population. Neurocognitive disorders are not going away anytime soon, which is job security for me, but bad for these people who seem to be find themselves in trouble with the law. Just wanted to hear your take on it.
Sneemac, so good to hear from you. I see you all the time. I don't know if we've heard from you before. Let's put you on the map. First of all, Alexandria, Virginia, in the house, and you're a neuroscientist. I just think that is so cool to be able to say. What do you do for a living? Oh, I'm just a neuroscientist. I guess you don't get the excuse of saying, what do I look like, a brain surgeon? I don't know if that's exactly a brain surgeon. In fact, I know it's not, but still close enough that you don't have the excuse. Thank you so much, Sneemac, for calling in. Another story I had not heard about, really interesting, and it does present some kind of gray area issues, as you say. Jose Veguilla is a older gentleman who had suffered a brain injury, which was also an interesting part of this story. And the brain injury is what caused him to suffer severe dementia, to the point that he couldn't care for himself and his family couldn't care for him. And he was put into a home for around-the-clock care. And he had bouts of unprovoked aggression and it wasn't something you could reason through with him because he's suffering from dementia and afterwards would have no idea what you're talking about. During his arraignment for this murder, he's in court and has no idea what's going on. He's suffering from that kind of dementia. But sadly, he is housed with another person who's in that same facility named Robert Boucher, who is an older gentleman. And I guess part of the issue was that Robert had been asked to be moved out of that shared room that they have. Before that was done, Jose beat him to death with his walker. Really horrific stuff. So what do you do with someone with dementia? How do you handle this situation? And to your point, Sneemac, there's no real clear answers. I mean, somebody's died. Somebody needs to answer for that. But do you have a person who has no idea what's going on around them answer for that? I don't know how it's done where this trial took place, but I will tell you with the small kind of experience I have with it here in California. In the most recent case that you may remember something like this being done is the Ron Jeremy case. Ron Jeremy was the porn star for so long. He was brought up on charges. There he is on charges of 34 counts of sexual assault involving 23 different women. He's very serious stuff, looking to go to prison for the rest of his life. But he starts to, or I don't know, starts or however it begins, but he, at the time that they are proceeding toward trial, he has been diagnosed and is suffering from severe dementia. First of all, in California, the first question is, the first hurdle, I should say, is competency. Is the person competent to stand trial? So we're not talking about insanity pleas. We're not talking about the responsibility of that person based upon some sort of mental illness or disease. We're talking about can they even stand trial for this? Are they competent enough to even reach that lower hurdle of standing trial, which is a low hurdle? It's basically, do you understand what's going on around you? Do you understand who the judge is, who the prosecutor is, who your attorney is? Can you talk to your attorney about the case? Not a very high standard. Well, when a person is suffering from this kind of dementia, they will be declared incompetent. And then there's a 2-year period where you can try to have that person regain competency. Perhaps it's medication, perhaps it's therapy, perhaps something can be done. But in a lot of cases, nothing can be done. Dementia is a deteriorative type of disease. You do not get better from it. You just get worse. And you cannot continue to hold someone in custody indefinitely pending their trial just because they haven't been declared competent. So in California, there's a 2-year period. If after that 2 years, that person has not been declared competent, something has to be done. And what they do is called a Murphy conservatorship. I believe it's from the case of People versus Murphy. And it's a civil commitment, essentially. And you have to prove that that person has been charged with a violent felony and that they pose a risk to the public and that they cannot be declared competent because of whatever condition. If those circumstances are met and a hearing is had, they then go into a civil commitment and they will be in a hospital receiving care and treatment for the rest of their lives. It's a indefinite time frame. So this is how we both address the constitutional issues that are still at play with the defendant and at the same time keep the public safe. If at any point they are ever regaining competency, let's say it's something not involving dementia, let's say it's something involving mental illness that can be treated, and they do regain competency, the clock immediately begins again. So it's not like this person gets out of this. They immediately go to answer for it. But in the case of Ron Jeremy, like I said, in 2021, he was charged with 34 counts involving 23 different women. In 2023, still had not regained competency. So they put him into this conservatorship. And the most recent development, and I know this is going to drive you guys all nuts, is that he was actually released to a private residence. Apparently he is bedridden now and he cannot care for himself. And so it was seen as being kind of the best situation for him to just receive care until it's done, until he passes. So that's where Ron Jeremy is now. But thank you so much, Sneemac, for asking such a wonderful question and getting us talking about an issue that we probably might not have visited otherwise. All right, let's keep it going here.
Hi, Josh. It's Aniki from South Africa again. I'd like to find out the concept of something being more prejudicial than probative. How do judges determine that? What should come in, what should stay out? For example, in the Adelson case, Rob Adelson is not allowed to explain exactly how manipulative and vindictive and controlling or bigoted his mother was with everything that happened to him. Yet in the Diddy trial, all the salacious stuff is coming out. How do they determine what stays in, what stays out? And I just want to caveat this. I do believe Diddy deserves everything that's coming to him. But why can it happen in one case and not in the other? Thank you for a great show. Have a good night.
Thank you so much, Iniki from South Africa. I love hearing from all these different places around the world, and I know we have a lot of listeners from South Africa, and I think that to a person that you're all from the Grizzly Nation, and I appreciate that. Thank you so much for asking the question. Interesting situation. So in the Donna Adelson trial, her son, Rob Adelson, is apparently a person that's on the witness list, and they intend to have him testify. but there was a recent ruling that he can't talk about a bunch of stuff involving his mother. And so I was not familiar with the insights, ins and outs of this entire issue. And I felt like maybe I didn't have an adequate enough answer for you. But Aniki, you may be able to stump me, but you cannot stop me. And that's because I've got friends. So I phoned a friend.
What's up, confidants? I just made that up. Get it? Courtroom confidential, keeping it confident, a confidant. So happy Memorial Day to everybody. Just amazing. The inimitable Josh Ritter asked me to answer a question that I don't know that I fully know the answer to, but I think I know at least most of it. And that is, in the imminent Donna Adelson trial, why is Rob Adelson, her estranged son, not allowed to testify to her character? And the short answer, it's exactly that. In a criminal court case, you basically can't assassinate someone's character because then you're literally, it's sort of a hearsay issue. This is a son who says this, and this. My mother's rhymes with which, or whatever he would get up there and say. However, and Josh can explain this further, the way I understand it, if there's something that is linked to the specific charges that she is being tried for, then he can come forward and talk about those issues. So if he overheard them planning, if he overheard his mother saying something disgusting about Dan Markel, yeah, then it's all fair game. But up until then, he cannot just get up there and simply character assassinate. Now, we're seeing it all over the Diddy trial, which I went up to for the first week. Sean Combs' ex-staff, his ex-girlfriend, ex-escorts, they're talking about testimony that is relevant to the case, but obviously, kind of incidentally disparaging him. But that, again, is related to the case. That is the answer. Coming to you live from the 305, even though I'm from the 732 in New Jersey originally. Hope you're having a great Memorial Day weekend. And Courtroom Confidential, man, it's the hot new show.
He's such a goof. Thank you so much, Joel from Surviving the Survivor, for helping us out and answering that question. I will tell you that Joel, I interrupted him in the middle of a Memorial Day pool/barbecue party, and I said, I don't care what you're doing, I need your help on this, send me a quick video. So he was always a trooper and kind enough to do it. It's going to get to the point, though, where all of my YouTube friends are going to stop answering the phone on the weekends because they know what I'm calling for. But again, that was great. That was really nice of Joel to do that for us. And it's a great question. Iniki and Joel did a great job of answering it. But kind of just to fill it out a little bit to your question, you said, is it more prejudicial than probative? We throw those terms around a lot. Obviously, what we're talking about is a balancing that a judge always needs to be done. Most all evidence is probative to some degree, and most all evidence is prejudicial to some degree. And many times you'll hear defense attorneys go, it's more prejudicial than probative. And you'll say, well, it's only prejudicial because it makes your client look guilty. But that's not really what we're talking about. The prejudicial is, will it be used in an inappropriate way more than it will be used in an appropriate way, is probably the better way of thinking about it. Will it be used more in a way that it should be used, or more in a way that it should not be used by the jurors if I allow this evidence in? And really what we're talking about here is what Joel outlined, is character evidence. Character evidence, we don't want people being convicted for their character. So when you're trying to introduce character evidence for some other reason, and you can introduce it for motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake or accident. We talked about this a little bit earlier with the question from Joe Schmo about LoriVallow. This is that 404B evidence. In California, we called it 1101B evidence. But it's the same thing. It's, when can you use evidence of character for a purpose not then character? And Joel put it right. You're not allowed to just go up and trash somebody. Say, this person's an awful person. This person's really mean. This person's really manipulative. Those are all character traits. You're saying who the person is, and you're trying to, or what could potentially happen is the jurors would convict them on who they are rather than things that they've done. And as Joel said, you can always call a witness to say the defendant said X, Y, and Z, or I watched the defendant do X, Y, and Z. So Rob can get up, and I imagine will testify to things he heard his mother say or things he saw his mother do. There's Rob, the only sane one in that entire family. But he cannot then say, and my mom, being an evil, manipulative witch, is probably the person who did this, and I'm not surprised that she did. That's where it has to stop short. So then your question is, well, what isn't that exactly what they're doing in the Sean Diddy Combs case? Not exactly. They're talking about a bunch of horrible stuff that he did. Sexual assaults he committed, things he orchestrated, things he said. But if you start to just say, and on top of that, he's a real a-hole, or on top of that, he's a real awful person, or he's really rude he's really mean to animals, or something like that, where you're talking about who they are, that's where it's going to stop short. But in a case with Diddy, where the whole thing has to do with an ongoing criminal enterprise, it's kind of like wide open as far as all of the different things he's done that they can get into. I hope that makes sense. This area of the law I find to be the most fascinating because it can be powerful evidence, but it's also some of the most misunderstood. So I think the best way to always think about character evidence is, as long as I'm not talking about who this person is and therefore their predisposition to commit this crime, I can talk about things that they've done if it helps out in some other way, in some other probative way. Anyhow, great question. And Nikki, super big shout out to Joel and Surviving the Survivor. Next time you guys are on his channel, please give him a shout out. Say Courtroom Confidential thanks you for the phone a friend. And I'll try to bug somebody for next week. All right, let's keep it going here.
Good morning, Josh. This is June from Stockton, and I have a question. I was watching the Karen Read show this week, and one of their experts tend to have omitted proper information in regards to resume and degree. The question is, if an expert is believed to have embellished his CV and testified in other trials as an expert, can the other cases be in danger of either appeals and or overturn of the verdict? This would be for both criminal and civil courts. I'm just kind of wondering, because I think that would be a dangerous field. Thank you. Have a good day.
Thank you so much, June. Stockton, California. Let's put Stockton on the map. June asked a question that's very topical of some stuff, the developments we've seen in the Karen Read case. ShanonBurgess was a expert called by the prosecution. Robert Alessi cross-examined him and made great strides with pointing out inconsistencies and perhaps misrepresentations that existed in some of his past resumes, I should say. I think the most accurate way of putting it was that the resume or the CV that he had handed over to the government was accurate, but that his LinkedIn and resume found on websites were inaccurate and had misrepresented his level of education. And Alessi just dug into this dude about that, just, you know, really hammered him on this. And a lot of people in the Twitter sphere lost their brains and set their hair on fire, and everybody reacted to this. And June's question is this going to cause problems for a person like this testifying in other cases, or for cases that he's already testified in? And the answer to that is, first, yes and no. This isn't like an officer testifying where they will be put on a Brady list and that, you know, every other trial they ever testify in, these issues could come to mind. But if other people research Mr. Burgess and he testifies in a case, I imagine they will find out this same issue. And whether or not the judge will allow them to get into it. First of all, I imagine his LinkedIn and resume have probably been updated at this point. But if he testifies in another case, can they bring this up? And can they accuse him of, you know, some sort of dishonesty for all of this? The answer is that they could try, and it would be up to the judge on whether or not to allow them to do it. And if they do it, I doubt it will have the same kind of gotcha moment that it had in this trial. Lisa Mitchell, pardon me. Thank you so much. Love your show from West Virginia. Why is this a state and not federal case? Talking about the KarenRead case. If you're talking about the KarenRead case, it's because it's a local homicide case, which the vast majority of them are handled on the state level. Even though there is arguably perhaps some federal jurisdiction, not often what you see the feds get into. I hope that's the question you were asking about, and I hope I answered it correctly for you, Lisa. But that's why. I mean, there are murders that take place all over the country, and they're usually handled on the state level. Very rarely do the feds get involved. If it's some sort of cross state lines issue or otherwise, maybe they would. But back to Mr. Burgess here. One little thing I'd like to add about this. Oh, Lisa was referring to Kohberger. Same thing with Kohberger. It's a state homicide. I mean, you know, the feds get involved in cases where it's perhaps a vast conspiracy involving interstate issues, people crossing state lines to commit crimes, mafia cases, stuff like that. Or you're talking about crimes involving perhaps military on a military base where they would have jurisdiction, things like that. But for the most part, most homicides are handled at the state level. The only exception that comes to mind immediately is Luigi Mangione, where they're doing it both at the state and federal level. The feds arguably have jurisdiction there because there was, you know, the idea that he had crossed state lines to commit this crime. But I think the feds just wanted involved more than anything. They just chose this case to say, we want in on this as well. And we'll see if they actually do end up prosecuting him for it. But that's, you know, kind of this federalist system, state and federal, you know, common jurisdiction issue that we've talked about before. But thank you for that question. Anyhow, back to Mr. Burgess here. Poor Mr. Burgess. I'm curious as to the effect that this cross-examination and about his education will actually have on the jury. I think watching it, we were all kind of like, oh man, he is ripping this guy apart. But I just began to think about how are some of these jurors reacting to this? Are some of these jurors sitting there going, first of all, what the heck is LinkedIn? I mean, not everybody's got a LinkedIn, right? I think some of them could be going, yeah, I got a LinkedIn. I haven't updated it in 10 years. I have a LinkedIn. I haven't updated it in several years. I recently, just because of this, went and looked at my LinkedIn and updated it. As far as like his college degree, I was wondering, is he hammering on this guy pursuing a college degree too hard? Are there people on that jury who are like, I don't have a college degree. What do you, are you saying I can't have the same kind of qualified opinions just because I don't have a college degree? Are you saying that I've taken a long time to pursue a college degree makes me less of a person? I don't know. I mean, I just at one point thought, you know, sometimes you may be feeling like you're driving home a real powerful point with the jury and you're not realizing how it might be rubbing some jurors the wrong way. If that happened here, we'll never, we might not know ever, but we'll see certainly if it had an effect enough in the verdict in this trial, if we ever in fact get there. But great question, June. Really appreciate it. Thank you always for your support and contributions to the channel. All right, let's keep it moving here.
Hi, Josh. My name is Sophia, and I am from Troy, Michigan. And I have to say that I just recently found you because I'm a true Grizzly member. So I've been listening to Gazilla for a while now. And because of her, I ended up starting to listening to your podcast. So I have two questions. One, do you think JenSoto will be charged for her daughter's I guess, killing or murder, however you want to call it? And two, do you think Wendi Adelson will also be charged for her husband's death? I hope you get to answer my questions, and I look forward to listening to you on Sunday. Thanks. Bye.
Thank you so much, Sophia from Detroit, Michigan. Grizzlies in the house. I see all the bears in the comments. Gisela, love her so much. She does incredible work. And she's got an incredible community that she's built, and always love all the love that we get from the Grizzlies. So thank you, Sophia from Detroit. JenSoto, will she be charged? I have to feel that if they have not charged JenSoto at this point, in my view, they probably are not going to charge her. Is that the right or the wrong thing? I tend to think it's the wrong thing. I tend to think she probably knew way more, is far more culpable. I don't get it. But they made a decision. I tend to think that if they haven't made the decision to charge her now, they're probably not going to do that. Now, Wendi Adelson, nothing would surprise me at this point. Wendi Adelson, usually you would say to yourself the same thing that I just said about JenSoto. They've already prosecuted several people. It's, you know, we're talking closing in on a decade since the murder took place. If they haven't charged her by now, they're not going to. But that does not seem to be the way that the prosecutors are operating down in Florida. And they have just been systematically checking people, knocking cans off of the shelf in this case. And, you know, first they started with the hitmen themselves, then they broadened out to the girlfriend, then they broadened out to Charlie Adelson. Now they broadened out to Wendi Adelson, or to Donna Adelson. And will Wendi be next on the list? I will say, as each trial goes on, she seems far and far more involved. If anyone benefited the most from all of this, you're looking at that person right now. I don't understand why the Florida prosecutors are being as patient as they are with all of this. So I will leave it at that. It would not surprise me at this point, not with this case, if after Donna Adelson's trial, we hear about another arrest. But thank you so much, Sophia, for asking the question. It's a question we get asked a lot. Why not and when it comes to Wendi Adelson? I don't know. I mean, you know, these prosecutors, I'm not going to second guess these prosecutors because I think they've done an incredible job. And maybe part of that is just showing some discretion when it comes to Wendi Adelson. Best gun losing detective. KR is not a homicide. It is undetermined. Yes, according to the medical examiner, you're absolutely right. It has been classified as undetermined, but it is a homicide in that they are charging her with a homicide, with murder, second-degree murder. So as far as the prosecutor's office in the Commonwealth of Massachusetts, that's the way they're treating it. But you are correct, best gun losing detective, that according to the medical examiner, it was undetermined. All right, let's keep it moving along here. Lisa Michelle says, I'm sorry, I should have specified Kohberger case. I've been focused on it. No reason to ever apologize. And thank you again for asking the question. And believe me, I've been focused on Kohberger too. I think it's a fascinating case, and I hope I answered your question. All right.
Josh, good morning. It's P. Lola's mom. I'm standing outside near the ocean, so if you hear any weird noises, it's the crashing of the waves. My question is about the Bryan Walshe case. So the Bryan Walshe case is happening in the same area as Karen Read. Some of the same officers are involved, some of the same investigators, which means that anything that was located at the scene will also have taken to the same techs who are testifying in Karen Read case. So my question is, we are all focused on the Google search from Jen McCabe. And a lot of the circumstantial evidence with Walshe is his Google searches. So how is it they're going to be able to use those searches and say they're valid in one trial and then invalid in the Read trial? I'm really curious as to what you would be doing as the defense attorney with that information, knowing that they spent so much time saying that Jen McCabe did not make that Google search at 2:26 a.m. And a lot of searches were done by Walshe on numerous computers, phones, iPads, etc. So I'm just curious as to what you do as a defense attorney to get over that hurdle. I'm sure they want all of that information thrown out. Thanks so much. I appreciate it. Of course, I'm here in New Jersey, and we're going to be spending the holiday weekend near the ocean. Lots of tourists, lots of fun. I hope everybody's enjoying their Sunday. Thanks again for a great trial week. Appreciate you. Appreciate our chat. Appreciate our mods. Thanks. Bye.
Oh, P. Lola's mom, we appreciate you. Thank you so much for all those kind words. Calling in from Mantelo King, New Jersey. I hope I'm pronouncing that right. Put you on the map. P. Lola's mom asked the question about there is a lot of crossover between the Karen Read case and the Bryan Walshe case. Karen Read, obviously, charged with murder out of Canton for the death involving John O'Keefe. Bryan Walshe charged with murder as well. He was from, I'm blinking on it. What's the name of it's going to hit me out of nowhere. The town where he's out of, but apparently still within the same jurisdiction of the state troopers there. Not Canton. It's he's in a different part of Massachusetts where this took place. Everybody's giving me shrugs. Cohasset, Lori wins it. What do we send Lori? Lori gets a big heart from everybody. Cohasset, Massachusetts. Anyhow, apparently under the same investigator's jurisdiction. In fact, Michael Proctor, I believe, was the lead investigator on the Bryan Walshe case as well. Or if he wasn't, he was one of the investigators involved in that case. And so a good question is, how is this going to affect everything? How is what spillover will Michael Proctor's issues in the Karen Read case have on the Bryan Walshe case? Or how about these Google searches? If the Google searches are being attacked in the Karen Read case, will that affect the Google searches that were recovered in the Bryan Walshe case? Let's take the second part of that question first, the Google searches. I don't think you're going to see any issues with the Google searches. First of all, there's a difference in attacking the content of the search and whether the search was made, and attacking when the search was made. So in Karen Read's case, nobody's saying that the search was never made. In fact, the defense wants the search to have been made. They're just saying it was made at 2:27 in the morning rather than at whenever it is, 5 something in the morning. In other words, they want it to have been said before the discovery of John's body, not after the discovery of his body. So it's everybody's on board. The search was made. Everybody's on board that what the search was. It just comes down to a matter of timing, which is a very different issue in the Bryan Walshe case, where they're trying to say kick out the searches altogether, and nobody's really arguing that the searches weren't made. They're just saying, we believe you had bad consent in order to get into those searches. So I don't think we're going to have a problem as far as like, our Google searches all of a sudden, out of bounds and nobody can use them. They will be used in Bryan Walshe. I don't think there's going to be any problems, and they're probably going to be used to some great effect because he searched for some ridiculous stuff. I mean, how long to dispose of how to dispose of a body? Can blood be it was just ridiculous type of stuff, including how long do you have to wait to collect inheritance? I mean, just ridiculous. But the other question becomes, what about Michael Proctor, and what effect could that have on the Bryan Walshe case? And this goes into, again, these ideas that departments now keep what are called Brady files, where anytime an officer has been found to have committed some sort of act of misconduct, they go into a Brady file, and that is something that has to be disclosed to the defense. So the misdeeds of Michael Proctor have been turned over to the defense team in the Bryan Walshe case, and they're going to do their level best to try to muddy up the Bryan Walshe case with some of the spillover from the Karen Read case. And it's going to be up to the judge how much of that comes in, because just because a cop happened to have done some shenanigans doesn't necessarily mean we're going to allow you to say that affected this case. If that doesn't really have a lot to do with the Bryan Walshe case, a judge may limit it. Now, if Michael Proctor takes the stand, I imagine the judge is going to allow it to say, you've been fired, correct? You were fired for some sort of misconduct, correct? But as far as, did you send all these messages about Karen Read, and were you looking for nudes and all of that kind of stuff? I think a judge is going to say that's neither here nor there when it comes to Bryan Walshe. But if you want to get into the idea that he's been fired, that's probably fair game. Great question, Pilola's mom. Sounds like you were having a wonderful time by the ocean. I hope you're having a wonderful weekend as well. I hope all of you are having a wonderful weekend, and I want to get you to that weekend, so let's keep it rolling here.
Hey, Joshua, it's Alicia K. Mayo from Humboldt, Tennessee. You can completely ignore my Diddy question because let's just say I got fever dream duped on that one. So here's my new question. What does the U.S. attorney do? I know it's a federal judgeship, but when Judge JaninePirro was placed in that position, it got me to wondering what's the difference between what they do and what other federal judges do. And happy Sunday fun day to all my crewmates, fellow jurors, mods, chat, guests, everyone. Thanks. Bye.
Thank you so much, Alicia K. Mayo from Humboldt, Tennessee, putting Tennessee on the map again. I'm not gonna completely call you out, but there were a few more than just your question, Alicia, about there was some rumor going all over the internet that somehow there was audio tape of Prince bashing Diddy, and that was going to be played in court. And then it turns out that was all just some sort of big hoax, and I don't know where it came from, but you're not alone, Alicia. Anyhow, her question, though, her redo question has to do with U.S. attorneys and what is their role. And she mentions JaninePirro being recently, and this shows you how busy I am that I didn't even know this had happened. But JaninePirro, who many of you may know from Fox News, she was a judge. She was appointed to be the interim U.S. attorney for Washington, D.C. And that is only for the jurisdiction of Washington, D.C. She wasn't appointed to be a judge. She was a judge before, but now she's been appointed to be the U.S. attorney. So whenever a new administration comes in, the president appoints the U.S. attorneys. And this will happen with almost every turnover in administrations, especially if you're going in between the parties, that they'll kind of clean house. They'll get rid of all the U.S. attorneys. They'll appoint a bunch of new U.S. attorneys. They have to be confirmed by the Senate. Many times they will work with the local senators to try to find someone that they're going to agree to. But it's really the president's purview to choose who these people are. The U.S. attorneys are the chief federal prosecutor in the judicial district of each judicial district. It's like a district attorney on the state level. The district attorneys are for each county, or however they break it down in that state. They are the chief prosecutor for that county. The feds break it down, and I'm going to show you a map here. They break it down. There are 94 different districts throughout and maybe I can make this a little bit larger. Can we do that, Kaylin? Okay, perfect. There are 94 different districts throughout the U.S. Each one of those districts has a U.S. attorney assigned to it, and they are the chief prosecutor in that district for all federal prosecutions. I live in Southern California. We are in the Southern District, it's called, of California, and we have a U.S. attorney for the Southern District. And if you want to do federal cases in this area, you have to be admitted to the Southern District of California. Those districts then all fall into 12 different circuits, which you also see here on this map. That is when you hear things like, oh, this case got turned over by the 9th Circuit, or, oh, they're filing this case in the 5th Circuit. That is where the cases, again, these are the judicial districts and circuits where they're handling a case. And each circuit kind of has what is perceived to be its own kind of political leaning. So the 9th Circuit on the West Coast, seen as being leaning a little bit more liberal. The 5th Circuit, including Texas, Louisiana, and Mississippi, seen as being a little bit more conservative. And what's interesting about federal cases is you can kind of file them in a circuit of your choosing, because its federal jurisdiction is the entire United States. So just an interesting little aside there. Thank you, Alicia K. Mayo, for bringing that up. And yes, JaninePirro is now one of those districts is just Washington, D.C., just the District of Columbia, Washington, D.C. Very small. It handles whatever federal issues within that district, but then it handles a lot of stuff dealing with the White House itself. Thank you, Alicia K. Mayo. Always great to hear from you. Let's keep it moving here.
Hello, all. I'm calling from the Saskatoon area of Saskatchewan, Canada, and I am already on the map. In Canada in 2008, TimMcLean was killed on a Greyhound bus by VinceLi, and it was pretty brutal. He was decapitated on the bus. VinceLi was essentially found not criminally responsible. I believe it was untreated schizophrenia. In 2017, he was released from prison, as he is now on medication and seeing doctors for it, and was found not to be a threat anymore. He changed his name to Will Lee Baker, and this caused quite a bit of conversation around here. So my question is there any kind of crime in the United States that would prevent someone from changing their name? And are things like sex offender lists automatically maintained if someone does change their name, or is it up to the offender to update that? Thanks so much. Have a great weekend. Bye.
Thank you so much, Jenna Bell and I know you said you're already on the map. I'm going to put you on the map anyways, mainly because I like to say Saskatoon, Saskatchewan, Canada. Thank you so much for calling in. Always appreciate hearing from you. This was a case I do remember because it was so wild. But I'm glad that you brought it up again for people who may not have heard of it. And this interesting little twist. Pardon me. I'm losing my brain. TimMcLean is riding a bus along with a gentleman by the name of VinceLi. VinceLi is suffering from some sort of mental unrest and attacks TimMcLean and decapitates him on the bus in front of all of the other passengers. Just horror beyond horror, horrific. He's arrested. He's tried. It's however viewed as a insanity defense. And he is, I forget if the outcome was that he was found not guilty by reason of insanity, or if he was found guilty but put into a mental hospital. But anyhow, he's out, and he's apparently receiving treatment and is not considered to be under the same psychosis that he was under at the time. And in the meantime, he changed his name from VinceLi to Will Lee Baker. And Jenabelle asks, wait a second, what's up with that? How is that legal? In the stories that I read, they didn't give an explanation as to why he changed it. I imagine he, as being notorious as he is, he didn't want to go around with a name like VinceLi and wanted to move on with his life, though I think he should be moving on with his life behind bars, but that's not the question you asked. Is there anything to have prevented him from doing that? Apparently not in Canada. In the US, though, when you are on probation, and I just wanted to show this to you guys, this is called a tall waiver. And it's not tall as in T-A-L-L, it's tall as in T-A-H-L. And I imagine that's, again, the name of a case. But this is oftentimes what is filled out when you're taking a plea for someone. And it's a couple of pages long here. And most felony pleas here in California, at least, are done through these waivers. And you will just have somebody fill this out. They put their initials next to every term that they're agreeing to. And this is a way of, one, expediting the process, and two, making it a little more rock solid so that people can't go back and later say, well, I didn't know what I was pleading to, and I didn't know what rights I was waiving, and I want to withdraw my plea, or whatever it is. You can say, well, you signed this thing. I asked you if you signed this thing. I went through this thing with you. Here's your signature next to every single term you've agreed to. You're locked in, dude. And this is the vast majority of pleas are taken this way, especially misdemeanors in California on these tall waivers. You just fill them out. Judge kind of reads it through. That's admitted into the file, and you go out along your merry little way. Well, one of these terms here, and I know that you guys can't really see it, but I'm going to read it to you. One of them, number 17, says, amongst other things, do not possess any blank checks, write any portion of any checks, have any checking account, nor use or possess any credit cards or open credit accounts unless approved in advance by probation or mandatory supervision officer. So don't do anything crazy when it comes to your money. Use only your true name. Do not possess any other person's personal identifying information or personal financial information unless otherwise approved in advance by your probation or mandatory supervision officer. So part of the plea that you take, and this includes whether you're doing it by a tall waiver or otherwise, at least here in California, includes the idea that you are going to use your true correct name for the rest of your life, that we don't want you changing your name, Mr. VinceLi, to Will Lee Baker, because we want to keep an eye on you, and we feel like people should know exactly who you are, and officers can readily identify you. Great question, Jenabelle. Look up that case, everybody. Wild, wild case. All right, let's keep it moving here.
Hi, Josh and Courtroom Confidential crew. This is Crystal, aka Court Lurker. I had a question about DNA, i.e. the Kohberger case. DNA is considered circumstantial evidence, correct? Thank you. Look forward to your answer. Have a wonderful day, and we'll see you all on Sunday Fun Day.
Court Lurker. So good to hear from you. Thank you so much for leaving the question. I love this question. love hearing from you. Tell us where you're from, court lurker. I just didn't get the location part of it, and we will throw you on the map. But great question. You identified Bryan Kohberger as kind of being what inspired you to ask this question, but I think it applies across the board, and it brings up a point I love to bring up all the time, which is DNA circumstantial evidence? Yes. Yes, it is. It's circumstantial evidence. And you say to yourself, well, I thought circumstantial evidence meant not that good. And we talk about this all the time in jury selection, trying to get people's heads wrapped around the idea that circumstantial does not mean bad. You hear this, on poorly written TV shows all the time. Well, that case is just circumstantial. Many cases are circumstantial. Circumstantial evidence can be incredibly powerful evidence. Circumstantial evidence includes DNA. Okay. I was so nervous. Spokane, Washington. Thank you so much. Well, great to hear from you, court lurker, and we will put Spokane on the map. But all that circumstantial evidence means, I think the best way to try to think about this is that direct evidence is evidence that doesn't need you to take another step in your brain. If I see, and the example always given, and I'm going to go ahead and put up the instruction here on direct and circumstantial evidence, but you guys can read it there. Maybe I'll read it to you really quick, and then we'll talk about it. But it's a little small, but I'll read it for you. It says, facts may be proven by direct or circumstantial evidence or by a combination of both. This is an instruction read to jurors here in California whenever there's circumstantial evidence. Direct evidence can prove a fact by itself. For example, if a witness testifies he saw it raining outside before he came into the courthouse, that testimony is direct evidence that it was raining. So you don't need anything else to prove that fact. I saw it raining. That's evidence that it was raining. Circumstantial evidence also may be called indirect evidence. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may logically and reasonably conclude the truth of the fact in question. This is what happens when you get a bunch of lawyers involved in writing instructions. They take too many words to say something simple. But it's basically indirect evidence. You need something else. One other step needs to take place in your brain. For example, if a witness testifies that he saw someone come inside wearing a raincoat covered with drops of water, that testimony is circumstantial evidence because it supports a conclusion that it was raining outside, though you did not directly see it raining. Both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental state and acts necessary to a conviction, and neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact in issue has been proven based on all the evidence. So quit beating up on circumstantial evidence. It includes DNA evidence. So you say, well, how in the world is DNA circumstantial then? Because DNA says, let's take Bryan Kohberger, for example. DNA says the direct evidence is that genetic material was recovered from a knife sheath. Why that is indirect evidence is it's the next step you have to say is that indirectly that means Bryan Kohberger touched that knife sheath, right? You didn't see Bryan Kohberger touch the knife sheath. Had you witnessed Bryan Kohberger holding a knife sheath, that would be direct evidence that Bryan Kohberger had touched a knife sheath. Finding his DNA is like finding the raindrops. Now we have to make one more step in our head. Now we know that that is indirect evidence that he at one point touched that knife sheath. But we don't know when he touched it. We don't know under what circumstances he touched it. We don't know if he touched it while he was in the house or if he touched it and it was placed in the house. We don't even know if he touched it directly, right? The defense is going to try to say, well, no, Bryan Kohberger shook hands with somebody who then touched the knife sheath because it was secondary transfer of that DNA. So that's why DNA and blood drops and fingerprints and all of these other things are circumstantial evidence. A fingerprint is not watching somebody touch something. It's saying that we believe somebody touched something because we found their fingerprint. We're not trying to prove the fingerprint. We're trying to prove that somebody touched it. So that's why fingerprints, DNA, blood droplets, all these things are circumstantial evidence. And quit beating up on circumstantial evidence. And thank you so much, Court Lurker from Washington, for calling in. Please call in again. All right, let's keep it rolling here. We're getting to the final stretch. And then we can get on with our barbecues and our pool time and whatever else we got planned for today. Hold on. Of course, we're going to hit technical difficulties.
Hello there, CC crew, Josh and Tiff. This is Subi Sue. Listen, I got a court trial for you guys. This is involving another Massachusetts cop. It's Massachusetts versus ShawnSouza, and it's ShawnSouza. There's the first trial landed in a mistrial. The second trial, he was found guilty by a jury and was sentenced to 10 to 15 years. What happened is that the court overturned the decision, and now they're going to have to do a third trial. Now he's convicted of, I'm going to say, rape of a child, 2 children, and indecent assault and battery. So what allows a judge to overturn a conviction that a jury has unanimously convicted? Don't understand that, so see if you can figure that one out. All right. I love this channel. Thank you so much for being here.
Thank you so much, Subi Sue from Reno, Nevada. Put Reno on the map. What is Reno's biggest little city? I think that's the motto. Thank you so much, Subi Sue. Appreciate this question. I had not heard of this case. Wow. This is another one that will blow your mind. And frustrate the heck out of you. So ShawnSouza, there he is, Dartmouth police officer. He is convicted in October of 2024 of sexual assault against children. Jury convicts him. Jury heard the whole case, convicts him. He gets 10 to 15 years state prison. This trial was actually the second trial. There was a previous trial where the counts had been separated. Those had hung. And in this trial, they joined all the counts together. So all of the allegations against different children had been tried in one case. A judge had ruled on that. A judge had allowed it. And the case proceeded forward in a joinder, which, by the way, should have been done in the first place. I don't know why it wasn't all tried together the first time around anyways. But for whatever reason it was, those were deadlocked juries. Now we're putting it all together in one case, and a judge allows that. Judge Susan Sullivan, there she is, presides over the trial. It's hard for me to really get mad and call out judges on this channel, but I am beside myself with this. She presides over the trial. She knows that these issues are at play, that this was a joined trial. After the conviction, she overturns the conviction, folks, kicks it out because the trials were joined together, and also because there was the presence of this group called Bikers Against Child Abuse. This is actually a really wonderful group. They are all motorcycle bike, like, I don't know if they're in bike gangs, but I'm talking like big Hell's Angel type dudes. And what they do is they will show up to court and just kind of support the kids in these types of cases, just make them feel like they've got a buddy, that they've got somebody behind their back. But apparently they were not like in court causing trouble. It's not like they burst into court in their motorcycles. They're just kind of there as big guys to make these kids feel protected and safe to testify in these incredibly awful situations. And I applaud the group. I think it's fantastic. But the judge said that their presence was an issue and the joinder. Neither of these issues was raised during trial, either by the defense, filed in any motions, brought up by the judge. The defense made a motion for new trial after this conviction, didn't raise these issues, didn't bring up the joinder of the trials, didn't bring up the bikers against child abuse being present. The judge took it upon herself to say those were a problem in a trial I presided over where I never brought it up as an issue at any point. And I'm not going to give notice to the DA to respond to this. And I'm denying a hearing on this and overturning the whole thing. The moral of the story here is that judges be crazy. And if you want to know what it's like to practice law, sometimes these are the judges you run up against. And it is beyond infuriating because what can you do? You can't do anything. You cannot unwind this. Now, the prosecution is trying to appeal this, and they're trying to get some other court. I imagine their only redress is going to be to try to retry him again. But I am just really shocked by all of this, especially too, because that judge could have easily allowed the appellate court to handle those issues. But for the judge, the presiding judge, to take it upon herself to do this, I don't know. Now, to be fair, I do not know all of the circumstances. I have not read the judge's ruling. I don't know if there was something that in all of this that might change my mind, but this one got my head flaming. Yeah, I wish I had the Josh rant emoji at this point because I'm just bothered by this whole thing. But it gives you, you want to ask me what it's like to be a trial attorney and what are the parts that I struggle with. This is it, judges. You will every once in a while run across a judge that just gets your head spinning and there's not really much you can do about it but smile and hope that you can prevail beside that. And if you can't, then you get red in the face screaming at the judge and you don't care. And have I ever screamed at judges? Sure I have. I'll tell you some stories about that another time. All right. In the meantime, though, this is it. Bringing us home.
Hello, Courtroom Confidential. This is Sonia from Chicago. Really, I just wanted to say happy Memorial Day. I think it's Memorial Day, right? But anyway, happy holiday weekend, everybody. And Josh, I guess my question is, what case are you paying the most attention to right now? Whether it's about to start or going on, there's so much happening. And if you could talk about anything, what would you want to talk about? Yeah, that's all. Thank you.
Sonia from Chicago, Illinois. Thank you so much. Thank you. Happy Memorial Day to you. Thank you for the well wishes. And I love this question. What case am I paying most attention to right now? There's a couple that immediately came to mind. The first is a case both of them are cases we've talked about a few times today. Bryan Walshe, I think, is a fascinating case. I for some reason, to me, it seems kind of under the radar. You don't see a lot of, the other YouTube channels talking about it all that much. To me, it's got all of the elements of what I think to be a fascinating case. It's a no body case. It's a circumstantial evidence case. But it's, involving, it's got also these people, well-to-do people living in Cohasset in this nice neighborhood. Her body's never been discovered. There's a lot of, we did an entire case notes on this, if you guys want to watch it, that we're probably going to be updating at some point. But it's, got a bunch of, the police were able to track him down to different locations and he appears to be disposing of things and the Google searches and all of this kind of stuff. Then he's also got this whole history with fake art. And he was like involved in these scams to sell fake art. So they just a lot of really interesting facets in this whole thing. But the biggest case that I am following and as much in the weeds as you can get on a case is obviously the Bryan Kohberger case. It's just a nightmare of a crime. 4 beautiful young lives stolen in the middle of the night, doing nothing wrong, being college kids, out having some fun, out getting some drinks, they go to sleep at night, stabbed to death. I mean, just talk about nightmare fuel. It's just every worst nightmare that we can imagine taking place. And then you have on top of it, the least likely of suspects, a PhD student, no real criminal history, no clear connection to the victims, no real motive that we can see outlined yet. I mean, it's like, you know, it's like stuff of fiction, this case. Thank you, Shy Gal, for asking the question. Just everything about it is the kind of stuff that I think draws us all to true crime is wrapped up in this case. And it will be a fascinating trial. And it is going to be a circumstantial evidence trial. And it's going to have a lot of all of these things all kind of put together in one case. And then it's the highest of circumstances ever. You've got 4 families whose lives will never be changed, who are looking for justice in this case. And then you've got a person who's on trial for their life, literally, because the state is pursuing the death penalty. So that case in particular is something I'm going to be following closely, and we will be following closely on this channel. But what a wonderful Sunday fun day. We talked about Kohberger and VinceLi, and we talked about BrianWalshe and KarenRead, and what are some of the other stuff here? Oh, how about that fascinating case out of Spain? You guys should check out that Murder by the Coast. We have to give again a big shout out and thank you to Joel Waldman and Surviving the Survivors for answering our questions. But what a wonderful Sunday fun day. Happy Memorial Day to everybody. If I didn't get to your call this time, don't get discouraged. Please call back again. We're doing our best to answer as many ones that we can. When I woke up this morning, I even saw brand new calls. And so I'm going to get to you guys all next week. Don't be offended if I wasn't able to get to you this week. We try to spread the love as much as possible, and we love to hear from you. Some quick announcements. What you missed on Saturday, we of course had our weekly roundup where we talked about Diddy and Bryan Kohberger and KarenRead and even BrianWalshe, a lot of the cases we talked about today. Stay tuned this week. All this week, we are covering the KarenRead case on our other channel. We will be live streaming every single day on Courtroom Confidential live trials. Search for it on YouTube. The handle is CC Live Trials. We've got all the cool kids in the chat. If you want to know where to go watch this trial and hang out with all of your Courtroom Confidential fellow crew members, that's the place to do it. It's a wonderful chat, and I try to jump in here and there where I can and give some commentary here where I can. And we wanted it just to be a place where you could all hang out and follow that trial. So that's on our other channel, Courtroom Confidential Live Trials. Yes, thank you, Afton. Please remember our fallen tomorrow through this whole weekend. It's great to barbecue and hang out with friends, and I think it's also important to spend a moment remembering why we're doing this. Monday, we are having the latest in our, thank you so much for the 4 months of membership from currently pursuing law degree, Aveda 2021, Mama She 13. Monday, we have our latest in our conversation series where I sat down with Joe Giacalone from True Crime with the Sarge. What a guy. What a fascinating character. Lived quite a life, had quite a career, and he just sounds like a dude I want to hang out and have a beer with. But he's a Mets fan, and I'm going to see past all of that. I like him in spite of all of that. And I'm going to be on his show coming up here soon too. But check that out. That will premiere on Monday at 5 p.m. Pacific, 8 p.m. Eastern on our channel, a live premiere, and we're going to bug him and make sure that he's in the chat. Wednesday will be, of course, Wednesday Night Live, and I think we're still working on a guest, so that will be to be determined unless anything's changed on that. Has it, Tiff? I don't think so. I think we were still kind of trying to throw together somebody for Wednesday, but the people we're working on, you're going to love and have a great time. As always, our membership is open. Where do you go for all of that? Hold on. Everybody calm down. All right. There we go. There's the guy. There's the folded arms guy. Go to thecourtroomconfidential.com. And if you want to join our membership, you can click on Become a Member, learn about all of the great benefits of that. If you want to check out our merch, you can go to shop. We've got all these brand new colors, including this one. What is this called, Tiffany? Blueberry or something? Raspberry surprise? Crunchberry, says Kaling. Crunchberry. All of these new colors are up and available for all you guys on our shop. And of course, where can you go to leave a message? Well, you just go, if you're sitting here and you're thinking, I want to leave a message. Why can't I leave a message? Well, you can go to thecourtroomconfidential.com, click on send a message, and then just start recording. And ask us something about true crime, or just tell us how much you love the show and tell us where you're from, and we'll put you on the map. Thank you, everybody. Thank you to our mods, Afton and Shy Gal, Kaylin and Tiffany, for all of the hard work behind the scenes. I hope you all have a wonderful rest of your Sunday and holiday weekend, spending it with your loved ones. Happy Memorial Day, everybody. Remember those who have sacrificed, the greatest sacrifice for all of us, and have a great weekend. Take care, everybody.